When the Affordable Care Act was passed, it was an act of Congress that the President signed. It included a number of very specific deadlines, very specific formulas, and what has happened as the implementation deadlines have come to the fore is that the administration on multiple occasions has relaxed those deadlines, changed the rules, said this part of the law, that part of the law won't go into effect on the date that Congress specified. A lot of people, in looking at those executive branch actions, have said that those are contrary to the law that Congress passed, but they were doubtful that somebody would have standing to bring a challenge to those executive actions. This action by the executive here to essentially eliminate an aspect of the law that Congress thought was important, namely that members of Congress and their staffs would be subject to the same health care system with its limitations as the constituents. That provision through this OPM rule has likewise been relaxed. What we think makes this different, though, and what we think gives somebody, and Senator Johnson and his staff members in particular, standing to raise an objection, is that this doesn't just affect everybody in the country. This is not an abstract concern. This is a provision that specifically affects how Senator Johnson and his office get their health care. It affects how the senator classifies employees within his office for purposes of their eligibility. So unlike a classic challenge to a statute that is a generalized grievance that affects everyone, this is a challenge to the implementation of a statute that is specifically directed to the Senate, Congress, their offices, and how they get health care. So we think that critically distinguishes cases that are out there that suggest that in many instances legislators do not have standing to raise objections in court. In particular, I think there are two things that really make this case very distinct. One is the fact that this directly impacts the Senate in his office and how he administers the office and how those individuals receive and pay for health care. So it's not a generalized grievance, it's a law that affects those offices specifically. The second thing, though, that I think distinguishes this from other circumstances is that oftentimes you have legislators bring court cases when they haven't been able to prevail in the halls of Congress. So the classic example is a senator who doesn't like the war in Vietnam or something and then brings a court action to challenge the legality of that action after having lost a vote to defund the war or something like that. This, in a sense, is the exact opposite. As both the senator and Rick have indicated, Congress specifically considered the question of whether or not members of Congress should get their health care in the same way as their constituents. They made a conscious decision in vote after vote, essentially to create parity with their constituencies. So if health care turned out to be a great boon, well, then all the boats would rise together. If it turned out to be a problem, then members of Congress and their staffs would suffer through the same problems and would experience those problems firsthand and perhaps would be best positioned then to address those problems. And in this sense, the OPM rule, and this is the heart of the challenge that's been filed today, really interferes with that congressional judgment. It stops what happened in the halls of Congress and effectively relaxes the impact of the decision that Congress made to make Congress and its staff members directly deal with the exact same health care situation as their constituents. And so that, too, I think really makes this a case where, unlike past efforts by legislatures to litigate in the courts, and unlike these other instances in which this administration has not implemented the law that Congress passed, this is a real ability in this case for the senator and his staff to raise this objection directly in court. So we do think, we feel confident that there's standing in this case, and we look forward to having the opportunity to litigate this issue in court. Thank you.
Now we're happy to open up to questions. Yes?
Now that you can't be on FHBP, how do you and your staffer get health insurance? And if you were successful here, what do you think is the most fair way for this situation to be remedied? Would you want to return to FHBP or?
Right. For my own part, I'll just tell you my own personal experience. My wife went on the DC exchange and stopped almost immediately because, first of all, she couldn't get through. When she finally did get through, just the amount of personal information she had to log on to the system. Certainly she was fully aware of the lack of any kind of security on the website. She just didn't want to go any further. So I support her in that decision. We actually ended up going to a broker in Wisconsin and just purchased healthcare still in the private market.